Продовжуємо засідання. Прошу
Let's continue our meeting. Please invite Kovalenko Denys Serhiyovych into the room.
Доброго дня.
Good afternoon.
Розглядається питання щодо
We are considering compliance of candidate for the position of the judge of the High Corruption Court Kovalenko Denys Serhiyovych with the criteria set out by Article 8.4 of the Law of Ukraine on the Hague. We have present members of PCAE, Robert Heinbruch-Eisen, chair of the PCAE, Norman Aas, remotely, Mary Kate Butler, Gabriel Yotkaitis-Kriskiene, remotely, John J. O'Sullivan, Jessica Lott Thompson. Members of the HQCJ present, Михайло Богоніс, Людмила Волкова, Віталій Цалюк, Ярослав Дух, Роман Капісюк, Надія Кобецька, Олег Колюш, Ігор Кошнір, Руслан Мельник, Роман Сабодаш, Руслан Сидорович, Сергій Чумак, Галина Шевчук. You have the right to request recusals, to submit motions on request of the chair, express objections and considerations. Do you have any recusal requests?
Дякую, немає.
Thank you. None. Okay, thank you. The rapporteur is Commission Member Kobetska Nadia. Please, over to you. General information about the candidate. I will not mention general information about the competition. The only thing that should be mentioned probably is that Kovalenko Denys Serhiyovych submitted an application. He was admitted to the qualification evaluation and participation in this competition, and pursuant to results of the first stage of the qualification evaluation, in particular qualification exam, he got 349.19 points and was admitted to the second stage of the qualification evaluation, that is examination of the dossier and interview conduct. Now, about the qualification of the candidate. In 2006, Kovalenko Denys Serhiyovych graduated from Yaroslav Mudry National Law Academy of Ukraine and received full higher education in the field of jurisprudence. In 2012, he got full higher education with a master's degree under jurisprudence specialty from the same law academy. He does not have academic title and degree. Now, with respect to the professional experience in the sphere of law, from 2006, namely from August 3rd of 2006 until October 3rd of 2007, he worked as a court clerk in a Court of Appeal of Kharkiv region. During the period from October 4th of 2007 to 27th of January of 2010, he was in the specialized tax inspection on work with large taxpayers in the city of Kharkiv, at first at the position of the chief state tax inspector of the legal department, and later on as the deputy head of the legal department. During the period from the 1st of February of 2010 until July 3rd of 2013, he was the head of the contract and legal department of the legal division of Bank Zoloty Vorota. On the 17th of July of 2013, he was appointed to the position of the judge, and until now he has been the judge of Rubizhne City Court of Luhansk region. From the 7th of June of 2022, he has been seconded to Kolomyia City District Court of Ivano-Frinsk region, where he is administering justice. Part-time, he is also the lecturer. From the 2nd of February of 2017 until the 31st of May of 2022, he was the senior lecturer of the Department of Law of Dal East Ukrainian National University, and from the 19th of October of 2023 till nowadays probably, he has been the senior lecturer of the Department of Law and Public Administration in Kindanil University. Kovalenko accordingly has a professional experience of being the judge of at least 5 years, and he has been the candidate in this competition based on this criterion. He has submitted respective declarations decisions. And during the conduct of the competition, the Commission sent inquiries to public authorities and other law enforcement bodies, among other things. We got responses that have been attached to the judicial dossier. Thank you. That's it from my side.
Дякую. Була нам
Thank you.
базова інформація, можливо,
Basic information has been provided. Maybe you would like to add anything? No, everything is correct. Thank you.
Пане
Okay.
Роберте, передаю вам.
Mr. Robert, over to you.
Thank you, Mr. Chair. I will be the rapporteur, so I will be the one who will be asking you questions. So my name is Robert Broekhuizen. Good afternoon. I hope you don't mind I say Denys to you. Is that okay? Okay, very
Yes,
good.
yes.
Maybe you can first explain why you want to become a Hague judge.
Якщо мова йде про
If we are
особисте,
talking about my personal motivation, then
чинником тут для мене
the factor here for me
стала війна.
has become the war. Because just like for many Ukrainians, unfortunately, it has demonstrated a high level of corruption in all spheres, basically in all spheres of public governance.
Ми всі побачили, що
We have all seen that its level is very high. Corruption is eating the state budget of Ukraine, budgets of local communities, and because of corruption, specifically, our teachers, healthcare professionals, pensioners are getting salaries and pensions that are not at the level of real subsistence minimum. Specifically, because of corruption, soldiers have low salaries. That is, in my opinion, the phenomenon that is killing the people's belief in fairness. And corruption is the thing that is slowing down our accession to the EU. I was asking myself personally what I can do in order to correct the situation. On the 5th of September of 2025, the High Anti-Corruption Court celebrated its 6th anniversary of its functioning, a very important work. For someone, ungrateful work, but I believe that judges of this particular court every day, through their actions, through their decisions, and not through their words, really significantly decrease the level of corruption. And as a judge, who, in my humble opinion, has necessary prerequisites set out by the law, I have decided for myself that I will take part in this competition because as a father of a small Ukrainian, as a member of the Ukrainian society, I really want to decrease significantly and as soon as possible a high level of corruption in our country. And I thought, and I still believe that if I can become a judge of the High Anti-Corruption Court, then among other judges of this court, I will be able to really, through my own actions, through my decisions, and not on my words, decrease the level of corruption in Ukraine.
Okay, thank you. I hope that if you are selected, that this is indeed what happens. And do you feel free to take decisions if you would be a judge of the High Anti-Corruption Court, that you are free to take any decision without any influence from the outside? Because not only in many aspects in Ukrainian society there are issues about corruption, but also in the judiciary itself. So how can we be sure that you are someone who will not be influenced by the outside world or by money or by politicians or by whatever?
Моя біографія
My biography and my work at the position of the judge
підтверджують те,
confirm
що
that
якщо
if
є якийсь чинник,
there is any factor, external factor, in particular,
в реєстрі
in the register of court decisions, there is my decision
заявляв самовідвід,
I recused
не
myself,
розглядав
and I
справи,
did not consider cases in instances when there were any
конфлікт інтересів,
conflict of interests or
на думку
in the opinion of external observers, I thought that I had to show, through my example, honesty, impartiality of judges that exist. And now with respect to the pressure,
протягом 12 років,
then throughout 12 years, I have been working as a judge, slightly more than 12 years. And I have considered many cases that are included into so-called high-profile cases in Ukraine.
суддівській практиці,
In my judicial practice, there were cases when I was considering
цивільні справи,
civil cases,
де з'ясовували стосунки,
where one member of the parliament was settling a dispute with another member of the
були
parliament.
справи, де
I had cases when I was considering issues on reinstatement of a suspended mayor of the city,
припинення дострокової його
termination of his early powers.
Repeat all your cases. But what you say, if I make it sure, is that you will not be subject to influence from the outside. Is that what you want to say?
Так,
Yes.
Yes.
Have you ever experienced that people want to try to influence you from the outside?
ну, якби
Well,
прямої ні.
direct no. If there were any direct influence, then I would have reported about that to the High Council of Justice. Because if there is an interference, then I'm obliged to notify about that. So no, direct influence, no. If you allow me, I will follow up on your question. Do you mean some offer to me or some requirement, demand from me? Or do you mean rather some, just for example, pressure of the public that is sitting in the court hearing?
Well, maybe someone who tried to influence you indirectly, or someone calling you up to say it's important that the case of Mr. X is decided in his favor, or a politician coming to you and say this is a very important case for the city, whatever. Because that sometimes happens.
Таких прикладів
No, in my professional activity at the position of the judge, I have not had any examples like that. If I had at least one instance like that, I would have addressed the High Council of Justice at once about that.
Can you imagine that I find it special if you say that you never had this because you have been quite a long time a judge and you have done high-profile cases, you say, and then I would expect if the case is a high-profile case in society in Ukraine, it may have happened.
Цілком слушна думка.
Absolutely correct remark. I can assume that it has never happened because,
Як зазначала,
as mentioned by Madam Nadia, the reporter from the HKCJ, I worked in two different courts. But in both of these courts, the first thing that I did when I came to the position, I held a meeting with my assistant and my secretary, and I informed them that I warning them that if I find out that any of them is engaging in corruption offenses or corruption-related offenses, then they would be at the very least dismissed, at the very least. About myself, I informed them that I perform duties and I came to work at the position of the judge exclusively in the honest manner. And at once I asked them, and I did that in both courts where I worked, and I asked the secretary and the assistant to inform all the authorities that Judge Kovalenko will never receive anyone's meetings. I do not receive citizens, that no one should come to me. If that happens, then I will respond according to the law at once. And besides, when I was introduced to their staff, I made the same statement at once to the judges. And I think that's the factor that worked.
So you have informed all the attorneys around you that you will never ever take.
Так?
Yes.
Так.
Well, if you become a judge in the High Anti-Corruption Court, then you will be sitting in a court with 3 judges. What if one of your colleagues would say to you, no, Denys, this is a very important case. I had a phone call by someone very important or rich, and we have to take a decision in favor of Mr. Y. Someone. What would you do?
Те, що я і сказав.
Just what I said. The law requires from me to notify the High Council of Justice, and I would do that.
I have noted that you don't spend easy money, but you like to go on vacation. You are someone who likes to go on holiday to abroad, isn't it?
Так, це
Yes,
спосіб
yes. That's the way
вчити і спосіб
to rest and to learn more about the world.
And you have traveled to Finland and to Italy, if I'm not mistaken, Egypt and other countries, Turkey. Can you tell us how you were able to pay for this? Because they're quite expensive kind of holidays.
Я дуже вдячний
I'm really grateful
вам і
to you
команді
and to the team
за те, що ви
for
надали мені.
giving me an opportunity to provide explanations about this matter, because
Я був сам.
when I looked through the dossier, I was really surprised that the border guard service provided information that I allegedly
Спочатку, получається, з родиною в
at first with my family in 2019 traveled to Helsinki. In 2019 and
в цьому ж році
during the same year, they also provided information that I was coming back from Egypt.
я надавав письмові
I provided my written explanations, and now I will repeat that. I have never in my life been in Helsinki, in Egypt.
Я надав,
I have provided.
я просто дуже радий.
I just very happy. Like by accident, I kept my passports for traveling abroad and the passports of my child for traveling abroad. Where is a mark in the passport that I, together with my family, was passing through the control in Rome and not in Helsinki, as mentioned in the information from the border guard service and from Egypt. I have never been to Helsinki or Egypt. And with respect to the trips, that yes, indeed, in 2019 and in 2021, my mom, my wife, and my son traveled to Italy. I'm stating that no one from my family members left the territory of Italy anywhere. And we were traveling there. Why? Because in Italy, for many years, my sister has been living. And we were staying at her place, so I did not spend any money on some hotels or on booking, etc. She is married. Her husband is a citizen of Italy. She also has citizenship of Italy already. They have their own house in which there is an opportunity to accommodate me, my mom, my wife, and my son. We were traveling there by air, by economic class. I have kept the border tickets, and I have provided that to you, and I have sent a copy to the commission of this boarding passes. We arrived in Rome. From there, by car, she picked up us because they have a car in their family, and we were staying at her place. If you allow, I will not name the address of her house, but I will say that there is a small town. It's not far from. Well, I cannot recall specifically, but I think it's about 15 kilometers from the sea coast. So all of that was around their house. In 2019, that was our first meeting of my sister with her nephew. And yes, we were traveling by car on the territory of Italy, but these were areas in the vicinity, not areas, regions, in the vicinity of the region where my sister lives. So, with respect to nutrition, so I was paying for food and my sister was paying for that.
What you say is that you did not travel to Egypt and Helsinki, but you did travel to Italy, and you didn't spend so much money because you were able to stay with family and eat, let's say, not too expensive. That's what you want to say, huh? You did went to Turkey, is that correct?
Yes.
Yes. And also there, you didn't spend too much money. Is that how I have to understand this?
I can name specific figures if you want. That
Thank you. No, that would not be necessary. Let's discuss your car. You acquired a Suzuki SX4. You still have that car? Yes? And you bought it, I believe, for 880,000 hryvnias in 2023. Yes, it's correct, huh?
Yes.
How were you able to pay for this car?
These were savings of my family, including my friends, that I was getting from my judicial remuneration for 2021 and partially for 2020.
Yeah, we have noted that you say that that the money was saved from your salary in 2020 and 2021. That's what you say. But did you have savings per 31st of December 2020? Did you have savings at that moment?
I had them, but their amount did not exceed the amount of 50 subsistence minimums when I would have been obliged to declare that as savings in my declaration.
That's exactly where I wanted to go, because your declaration of 2020 doesn't show any savings, huh?
Yes, that's accurate. That's true.
And that means that because you say that the source of funds was money from savings from 2020 and 2021, the majority of the savings would have been in 2021.
Yes, absolutely correct.
But then you saved a lot in 2021. Yes?
Yes.
And were you still able to eat? Because then there would not be so much left.
Well, I don't know. How can I try to prove my frugal lifestyle? I am stating that neither I nor my wife, we do not have such a lifestyle that would envision, I don't know, going to restaurants, cafes. So the money that were spent in 2020 and 2021, I mean 2021 mostly, in 2021, I did not have a need to buy clothes, shoes. My wife, same. The son, yes, we were buying something for the child, but that was not something significant. The city council provided us with housing, so accordingly, nothing significant was bought back then. And for us, it was really the goal. We really wanted that, because in our family, we have never had a car before that. And that is the first car that we have in our family.
So what I understand is that you say that in 2021 you didn't buy any clothes. That would have been difficult. No shoes, no shirt, no.
Чому?
Why?
Чому?
Why?
Якщо
Well,
я можу,
I
я
can.
думаю, що це
I
може
think that it might give you an impression about my lifestyle.
в 21-му
In
році
2021,
я 6 днів на тиждень
6 days per
робота,
week,
будинок,
work,
робота,
home,
будинок,
work,
пішки,
home,
15
by foot,
хвилин,
walking,
10
15
хвилин
minutes,
я вже був.
10 minutes, and I was home.
Все.
So that's it.
You were wearing clothes too, then, I hope, and shoes.
Так.
Yes.
Yes. Okay. We have asked you some questions, you recall those? And we asked you a question about a speeding ticket that you have received in October 2025. You recall that?
Yes. Yes.
And then your answer is, I had the right to drive since 2018. And all the time I've been driving vehicles. This is the first time I have encountered the situation. So you never had a speeding ticket until 2025, huh?
Ні, до цього.
No.
Так, до цього.
Before that, no. No.
And we were wondering, were you driving any car? Because you only bought the Suzuki in 2023, and we didn't see any declaration of other cars. So, and your answer indicates that you, before you bought this car, had been driving a car.
Так.
Yes.
So, whose car were you driving before you bought the Suzuki?
Два автомобілі.
Two cars.
Це автомобілі.
That was, these were the cars of my friends.
Є користування.
And my use was once per 2-3 weeks.
Як я вже зазначав,
As I've mentioned, I was working, it was really 6 days per work when I was working. And one day, on a day off, every 2-3 weeks, because that was the car of my friends, other people. But I was asking them so that I could maintain my driving skills after passing the exam, so that I would just go to a nearby settlement together with my family, not far from ours. And that's how I was using their cars.
Thank you. We have noted that you have considered 404 cases about drunk driving, and that you closed only 9 of them. And there are other judges who close a lot of them, and you are not. How is that possible? How is it possible that you are able to decide on those cases on time?
Ну, я не
Well,
вів статистику.
I did not keep statistics.
Можу і не буду.
I cannot and I will not comment, and I have no right to comment on decisions of my colleagues.
Скажу тільки за себе.
I will tell you only about myself.
Коли я
When I came and started working in Kolomyia,
відсоток
then the percentage of cases that I was closing was much higher.
Я проводив
I conducted the generalization of the case law under Article 130.
2 роки поспіль.
And in 2 years in a row, I summarized the case law from the police. And then after that, the first time it did not help me much, I will be frank with you. But for the second time, the results improved.
Okay. Thank you. And I've seen that a few cases where you refuse to impose a penalty because, and in your motivation of the judgment, you say that you didn't take a drunk driver his driver's license because a person was dependent on the ability to drive a vehicle. I would say if you're a drunk driver, And when you are a professional driver, this is even worse because you will be on the road much more. And if you're a professional driver, you should know that if you are going to be drunk, you lose your license. And you decided that the license should be kept in 9 instances by the driver. Can you explain that? Why did you take away the license even though the risk for the people would be larger?
Я виходив з необхідності,
So
оскільки
I
в нашій країні, на жаль,
took into consideration
Кодекс
the
України
circumstance.
про
The Code of Ukraine on
Стаття
Administrative
130,
Offenses,
зокрема,
Article 130,
не містить
in particular, does not
варіантів
contain
при
any options
накладенні адміністративного
when
стягнення
it comes to
для
administrative penalty
суб'єкта стягнення.
for
Тобто я як
the
суддя,
offender.
не
So I,
маю
as a judge,
можливості, якщо суто
cannot,
виконувати норму
if
статті
I
130,
if I were to obey the Article 130,
щире каяття людини,
I cannot take into consideration
вчинення правопорушення
the
вперше, сприяння
the fact that the offender pleads guilty, that they regret their actions, and that was not a criminal case, but anyhow, the mens rea, the property status of the offender, and 3 decisions of the Constitutional Court say that such norms are not constitutional because they do not provide the court with the possibility to apply the individual principle of punishment. So in such a situation, I'm, as a judge, obliged to use the Constitution directly. And this is why I apply the principle of individualization based on the 3 decisions of the Constitutional Court. And if I were to respond to your question concretely, why I was supposed to assess that circumstance as a graver one. So I believed that the offender committed that offense not when they were transporting cargo or passengers, but that happened, that offense took place in their private life. That person committed that offense for the first time, and they have been a professional driver for a long time, and they have been indeed a professional driver, a driver by trade, and their income, or if I deprived him of his driving license, he would have lost his income immediately. And because he has worked for many years as a driver, I decided that would be a disproportionate penalty. And this is why I refrained from applying that punishment. But this is an exception.
Okay, thank you. I don't think I have further questions. Questions here on the screen? No, back to you, Mr. Chair.
Дякую. Пані Надія.
Thank you, Nadia. Over to you. I would like to talk to you about certain statements of yours, conclusions, rulings that you mentioned in your written explanations that, in my opinion, are not backed by facts, but I hope that you will dissolve my doubts. So you already mentioned that during this session, when Mr. Robert asked you about your motivation to participate in this competition, And as you are stating in your explanations, the war has shown us the real scale of corruption, and state budget and local budgets are suffering from it. And because of corruption, our children have less varied and less high quality food at schools, and parents cannot pay for their children tuition at other schools. Could you please back such statements with facts, especially the last statement regarding impossibility to get a spot in the public universities, impossibility to be enrolled and get a scholarship at public universities. So in my opinion, we have the reform that ensures that talented children do get these opportunities. So why do you think talented children have a hard time getting their spot at public universities? On many occasions, I read in mass media messages regarding the fact that pre-trial was done on the basis of the sale or sales of the state exam questions, leakages. Well, this is mass media, and we could say that the judge of the Kolomia City District Court is corrupt and doesn't consider cases appropriately. Are there any decisions, court verdicts? I haven't monitored that, but I just encountered this information regarding the pre-trial. And such a fact was registered in 2021 that actually happened some aspects of the events that you are mentioning. But whether we can state that talented youth cannot study at public universities and get scholarships, I'm not sure that this is a truthful statement. Then regarding the lack of variety and quality in school meals, why are you making this conclusion? Same thing, a notification of pre-trial regarding low-quality products procured for schools. And that is done because some officials get bribed or offer bribes when it comes to procurement. So, but you are relying on the facts from the mass media, correct? I knew. So if I wanted to, I would have found solid facts. I'm just reading you aloud your statement, and you as a judge, you need to back your statements with facts. Okay, that is clear. Thank you. So if we continue, then you told us that regarding the work of the Hague Court, that this court celebrated 6th anniversary recently, and each decision of this court contributes to the fight with corruption, and that is not on paper. And do you consider the Hague Court to be a element of the fight corruption prevention, corruption countering? Well, directly, it is not one of the bodies countering corruption. So what are the main functions of the Hague Court? So, what are the main functions of the Hague Court? The first function is to administer justice in accordance with the law, so that an individual, society, and the state are protected from corruption crimes, corruption-related crimes. Then the judicial, exercising the judicial control over investigations, exercising judicial control over the rights and freedoms and interests of the parties involved, consideration of cases related to unlawful enrichment, and cases on administrative offenses and imposure of penalties. So in the end, this is not a body directly countering corruption, but a body involved in this process as a judicial branch. And so my understanding is that you are very determined in this area. Would you be able to be free from bias when considering cases? I respect the presumption of innocence of each individual that is stipulated in our constitution, and this is our an important milestone. I will not accuse a party once a case comes to my consideration. So I will not see them as a suspect in advance. I will not be biased. Then another question regarding your professional experience and skills that will assist you and qualify you to be the Hague Court judge. You're saying that for the last 2 years you have been working in a court with a bigger workload than on average in Ukraine, so you are good at time management. And sometimes it happens that you work 10 to 12 hours per day. And you're talking about Kolomyia, this city district court. What is this bigger workload? Where do you take the data? I'm using the map of workload that is published on the website of the judicial power, where workload is defined for each court, and this information my colleagues and I get at the state administration. And the most recent indicators were 387 days. This is an average indicator in Ukraine. One colleague at our court, okay, I got you, just wanted to clarify the source of your data. We might be using different sources. So you're using the data from the state administration in 2023, 2024, 2025 in the Kolomyska City District Court had a lower workload than on average in Ukraine, according to my sources, which are official. And according to the official data, workload was not bigger, but still you are saying that you may be working for 10 to 12 hours per day. And then my question is whether you will be able to effectively work in the Hague Court where the workload is even bigger. I could reply. So this state administration is counting the days according to the number of the employees. And in 2023, we had a colleague that passed away. Unfortunately, she was terminally ill, and I have a certificate dated 2025. she only worked 3 days. She only had 3 working days per year. So we have official information, the number of judges, number of those who are exercising, and those who are not. And this is official information that the state court administration provides us. Whether the court calculates the days differently, it's up to the court and also to the state court administration. And you can also turn to the state court administration to clarify whether they are taking into consideration all the facts and circumstances. And one more question. Based on your explanations, you are saying that when a case is considered by a panel of judges with the jury, you needed to provide additional reasoning, and you are concluding that you have an experience of procedural conduct, and even if you disagree with the decision of the majority of judges, and if I'm appointed as the head court judge, I'm able to stand my ground and make my own conclusions. So, and you state 4 cases like this. 2 are identical. One dated May 2023, the other dated August 2023, and in all those cases the jury were different, and 2 identical thoughts relate to the case on extending the decision on incapacitation. And in your reasoning, you emphasize that when considering that case, and so it seems to me there were failures to observe the procedural rules, that is, rules of procedure, and there should have been a psychiatric examination conclusion. And you are stating that most of colleagues and to jury believe that it was enough to have the conclusion from the therapist, but we remember that the therapist doesn't have the necessary mandate. So you acknowledge that that piece of evidence was not admissible as a fully as a comprehensive evidence. So, of course, as the head judge, could you explain to the jury that the law required a psychiatric examination? I explained that 2 times, and I didn't do it for the 3rd or 4th time because it could have been qualified as influence. So you explained that to the first composition of the jury and the second composition of the jury, and they still approached that case in that way? Yes, this is true. And your second piece of reasoning, it was about adoption of a child, and you are saying that it was a dispute about the right, and a claim should have been filed, and under those circumstances the case needed to be closed. And again, the jury disagreed with you about a procedural aspect. Yes, that's true. And again, I explained 2 times to them about the consequences, that the case would be heard later. Thank you. Good afternoon. One question. So, regarding your practical work and your trips abroad. So the information about 2019-2021, when you took flights from Boryspil to Helsinki, Geneva, and so on. So beyond your surname, there is a serial number of a passport, and that number coincides with the passport, a Ukrainian passport that you indicate in your questionnaire. So do you confirm that beyond your trip to Egypt, the other information doesn't relate to you? No. Except I didn't go to Helsinki. I didn't go to Egypt. So stamps in my foreign passport that I took a flight from Boryspil and landed in Falconara airport in Rome. I've got proofs of that, and I provided that proof to the PCIe. So we all cross the border from time to time, so I'm trying to clarify that. And in the databases, the information is still there. So you confirm that information from the database regarding those flights are not true, and that is relates to someone else, not about you. Could you explain that part of those part of that information from the register you confirm, and the other part you deny? How could you explain the same surname name? I don't know how it could have happened. A couple of questions regarding your work. Remember the verdict that you made? So you applied you did not take into consideration the force of the law in time. So you applied the norm of the law that was effective at the time of the offense. So this is the paragraph about actus reus. And the data there is 2,000 subsistence minimums. What are the criteria for you? Which criminal law to apply? Article 5 of the Criminal Code regarding the force of the law in time. If we are talking about raising the threshold for liability,
і це відбувається після вчинення, такий закон я застосувати не можу. Якщо
I cannot apply the law that allows me to raise the threshold if it had been adopted after the offense. If the threshold is lowered, then I need to use the retrospective force of the law. So 500 subsistence minimums used to be the norm, and now the norm is 750. Does it improve or worsen this punishment? In that concrete situation, it did not affect the suspect in any way. Okay, thank you. Another question. So we are talking about subsistence minimums for people of working age. In that same paragraph, you are stating that the declaring under the tax code, and the minimum norm was 671,000 hryvnia. So I divided that. So the subsistence minimum is in 2023 was 683,000 hryvnia. Why does the tax code say that there is a percentage, but you refer to a different norm regarding the subsistence minimum of the citizens.
Значить, помилився.
So I must have made a mistake.
Я не пригадую, як я цей момент
I
описував.
don't remember how I
Помилився,
described
моя помилка.
this, but from what you're saying, it looks like a mistake.
До ноутбука спецконфіскацію ми тут вже неодноразово
You applied
це питання.
specialized confiscation of a laptop, and you refer to three criteria when determining punishment or means of criminal liability. Do you always use the three components test? If no, then why did you refer to it regarding this laptop?
Про кримінальну відповідальність. А питання про трискладовий тест, на мою
First of all, I'm applying the law on criminal responsibility, but the three-part test should be taken into account by the court, but secondary if we are talking about interference with the right of ownership.
Так, але
Yes, but here
про покарання.
we are talking about punishment,
А спецконфіскація
and special confiscation is not a punishment.
Тобто в випадках, коли
So in instances when the criminal sanction is about property but is not a criminal punishment, then you are applying this three-part test.
я не можу
Yeah, I cannot tell a state for sure that it happens all the time, but in each specific situation, I'm looking at that and seeing. Maybe have the system of criteria in which situations you are applying this three-part test, and in some instances you are not doing that.
Загальне правило спочатку
The general rule is at first the law on criminal responsibility, and secondly whether it's included into the punishment if or no. If yes, then no three-part test is applied. And the third point is that it's not a punishment but some measure like that. Then I'm looking at the three-part test. Okay, thank you. Denys, good afternoon. I have a couple of questions about your declarations. I would like to follow up on some aspects that are not very clear to me. Now, with respect to the car, firstly, tell me please, what was the price of this car? 882,000 hryvnias. So in section 6, 882,000 hryvnias, that's the correct values. Yes, as of the date of acquisition, yes. But at the same time, when I'm looking at section 14 of the same declaration of 2023, there it is specified 832,000. The difference of 50,000, something. Section 14, these are expenses and transactions. Expenses. Same vehicle, same date, but the amount is lower by 50,000 hryvnias. Yes. The matter is that payment for the price of the car happened in two stages. At first, I paid as advance payment 50,000, and then I paid the main amount under the agreement that exceeded. Okay, clear. Understood. It just understood. Another question that, frankly speaking, is not very clear to me. Maybe you will be able to explain. So, Rubizhne and Kolomyia are towns with a population lower than 100,000 people and no additional payments, regional, as we are calling them. So, remuneration should be the same, right? But for some reason, in Rubizhne, it was much higher. Even though the longer the judge works, then the higher additional payments are for like the length of service. Let's talk in figures. 2021, that's the last year when you worked in Rubizhne, 1,203,000, yes? In 2023, that's already in Kovalenko region, the first year, 1,043,000. So a significant difference. Can you explain that? Maybe you paid out something? I think that probably that was the payment once per year of financial assistance, yes. What about Ivano-Frankivsk region? They are not paying that? They are paying that, but the judge is submitting an application when the judge needs that. So I can use it for the next year. So you cannot recall. I cannot recall why we have this significant difference, even though it cannot become lower for the judge. Everything was declared. I was engaged in teaching activities with the university. Okay, then. In continuation of the topic of your savings, indeed, you did not declare that. Then 2 years before the purchase of the vehicle, you were declaring financial assets, $15,000, 7,000 euros. Then you bought a car. Obviously, in 2023, you did not have any financial assets after the purchase, but the situation is the following. You have a very modest lifestyle, right? Yes. But in 2024, the financial remuneration is the same, nothing changed. You are also teaching in the King Danilo University, but there are no financial assets. Yes. You started buying more? No. The price of life has increased. And in Rubizhne, I had an apartment, and in Kolomyia, I'm renting. I'm paying rent. Plus, my mom has also moved. And in Rubizhne, as far as I understand, the apartment was owned by the city council, and you were granted into use. Yes, yes. That's the reason. So everything that I'm getting now is being spent on current expenses. So the price of life has increased. But the financial remuneration, unfortunately, remained the same for the first instance judge. Yes. And that's the reason for that. Yes? Okay, thank you. Thank you. Do we have any other questions? Yes, please. I have one more question. You have separate opinions, dissenting opinions. In particular, there was mentioned the dissenting opinion on the case on adoption in the parliament. On the March of 9th, there was registered the draft law that envisions that decisions on adoption cases can be adopted by the judge without the participation of jurors. You are the practitioner. In your opinion, will this initiative be useful for adoption, or does it have any risk? Not useful. Not useful. Why? In my opinion, cases with the participation of jurors give an opportunity to us as the judiciary to show how administration of justice is happening, how decisions are taken. That's direct fulfillment by us, not directly, but it's an opportunity to report to people. They see how the court process is happening, and only after that they really become aware of why courts take these particular decisions and not something else. And after all, that's the demonstration of people's will, and that's direct democracy. And I only support that because jurors who take part in the court hearings, they come home, they tell their close people, relatives, as to how the proceeding was held, how the judge was behaving, whether the judge was violent, loud, drunk, swearing, how we are. That you can answer broadly, but not that broad. No, I was only asking about the legal perspective, whether if jurors are not there, won't it narrow down the interests of children? That was the perspective from which I was asking this question. But about the shameful instances that you probably know about this conduct of judges, I think that's happening very rarely, what you are saying. That's why I was asking about the interest of children mostly, probably. If we are talking about interests of children, then again, I support the idea of having jurors because I, as a lawyer, am looking at that, and they are looking at that as parents, mothers. Okay, that was my question. Thank you. Colleagues, I have two questions. One more general question, like Halina asked. You started your speech by saying and explaining your attitude towards corruption, quite substantial. explanation how triggering this phenomenon is for you and how acceptable is it. And that makes me think that probably you have been thinking for a while over these corruption risks that emerge in our country. Unfortunately, they also sometimes emerge in the judiciary system. And so I have a question, but please be concise. 3-4 sentences, if you have the answer. In your opinion, 3-4 advice. What would you advise to change in the country or in the judiciary so that the level of corruption manifestations would be decreased? What considerations and ideas do you have? What has to be done? I would try to suggest to the members of the parliament to expand instances of remuneration for whistleblowers, first of all. That's firstly. Secondly, I would, after all, strengthen responsibility. I would strengthen responsibility. In my opinion, in totality, that could work. But I think that the state is working with consequences of corruption, but it's not working with a prerequisite for its emergence. That's why I'm asking this question, because those two things that you've mentioned, again, they are more about consequences, I think. Yes, maybe there should be something preventive. Yes, preventive. If we could somehow in 1-2 days increase the level of wealth of our people, then I think that the general wealth improvements would also help to decrease the risk of corruption. Because in my opinion, people who are engaged in corruption, they are being governed by instantaneous things, like there is the satisfaction of the aspiration to get money here and now. So preventive function is to improve the financial situation overall, probably of those persons who can be the subject of these crimes. And that, in connection with that, I have expected question. You are getting approximately the same salary as all other judges of the first instance. Obviously, there are some differences in connection with the length of services, but more or less it's the same. And in your activities, you do not have this corruption. So the level of remuneration that you have, like your financial situation, is not in causal link, as it seems, between you, for example, not committing corruption offenses. Maybe the level of the financial situation is not a criterion that should be paid attention, because it's not impacting you. So that's not the only criterion. It's clear that, in my opinion, the state should implement an entire program for the introduction of correct values. I, for example, do not see some state program on that, about the role of the state in the society, how important it is for all of us to live equally before the law. What can it give? What can it give to the person that this person will follow the law equally to others? Okay, thank you. And in this regard, the final question, I've looked through the dossier. You are an active participant of judicial self-governance, and now you are demonstrating that you are thinking about these general problems, that you have some pieces of advice, thoughts as what should be done. And given your extremely negative attitude towards corruption practices, as you mentioned at the beginning of the interview, tell us, please, from your previous professional experience, what measures did you take personally, any measures, in order to improve the situation somehow with such a negative phenomenon as corruption in the judiciary or in the country overall? First of all, work at the position of the judge speaker. I'm trying to openly tell about the existence of the system and how the system is working, including through that. Because of that, I started teaching, because I believe that our education of our future lawyers is the beginning of attitude towards the law, corruption, judges, And when they see a judge in front of them, and the judge is telling them, in my opinion, correct things, then it can help. I'm not saying definitely, but it can be an additionally small grain of sand, small contribution to the development of that. Okay, thank you. Your position is clear, and your approaches are clear. And a short question of not the worldview nature. We've already mentioned. I still have an open question. These border crossings, because during interview with respect to each candidate, we are studying these instances, and we've never received any inaccurate information from the State Border Guard Service of Ukraine. I would like to follow up. We asked you whether you flew to Helsinki or no. Maybe on that day you just flew to in other direction, but not to Helsinki. I just don't know. What else can how else can I prove? Apart from, I've provided boarding passes clearly for a specific flight on the same flight back. The boarding passes. I have marks in my passport. No. Did you fly to another country on that day? On that date, there is no, 6th of September. You did not fly anywhere. You were not in the airport at all. In 2019, I, my mom, my wife, my son, the four of us, we were flying only to Rome, but on other dates. Dates. I do not see the dates now. I just do not have this attachment I've provided to the Commission and to the PCIe. I've provided, there you can see dates. The 23rd of September, Kiev, Rome, Kiev, but you were leaving on the 6th of September. Yes. I cannot imagine how it could have happened. Do you remember the date when you flew to Rome? Well, specific date, I cannot name it, because if that's the 6th of September, it can be a mistake. I even provided tickets for train from Rubizhne to Kiev, so that the commissioner and the BCE would have a chance to make sure that, yes, indeed, the entire family came from Rubizhne to Kiev. From Kiev, we came to the airport. We boarded the plane all together. We arrived there to my sister. I provided all the documents about my sister. We were there. We came back. And in 2021, the situation was the same. Okay, thank you. In continuation of this question, then I will ask another question. You've provided copies of your passports for traveling abroad with marks outside of the border control. Did you cross the border of Ukraine, of those countries that are mentioned in the question? I'm saying no, never crossed the border and never been to Helsinki or Egypt. My next question, do you have another passport for traveling abroad where this mark could have been put? Understood. No, I do not have any other passport for traveling abroad, and my family members do not have any other passport for traveling abroad. Okay, that's it. Sorry, if possible, I thought that it's Boryspil. They have tons of flights. Maybe they just somehow made a mistake with a flight, and that's why I put it. That's my assumption. Okay, understood. Your answer is understood. Colleagues, do you have any more questions? No? Dear PCIe members, do you have any questions?
I don't expect so. No, thank you, Mr. Chair.
Okay then. Okay, Mr. Denys, you have an opportunity to address the Commission and PCIe members. Maybe you would like to add anything. Over to you. First of all, I would like to express my gratitude to the team and members of the Public Council of International Experts for giving me a chance to publicly and openly answer the questions that really were of public interest. I would like to express my gratitude to Commission members and your entire team and the apparatus, because in my humble opinion, you have managed to ensure a fair competition among all candidates on equal conditions. And separately, I would like to express my gratitude to our defenders, because I believe that neither this competition nor our state would have not been possible without them. Thank you. Thank you for your participation in this interview. Now I'm announcing your interview over. Thank you. Goodbye. Thank you, goodbye, colleagues. I am announcing a break.